Good afternoon, everybody, and a warm welcome to our webinar on confidential information, rights, restrictions, and remedies. My name is Sven Clarke. I'm a legal director in the commercial litigation team here at Myerson's, joined by Robert Brothers, who is an associate of the team. And in a late change to the lineup, I'm pleased to report we're also joined by Jordan Buckle, a solicitor in the employment team at Myerson, to say a few short words on the topic from an employment law perspective. By way of a quick rundown of the topics for discussion this afternoon, we'll be looking to cover off the following. What is confidential information, its importance to the business, what information can and cannot be protected, the duty of confidentiality, trade secrets and how they operate alongside the duty of confidentiality, practical steps a business might employ to protect its confidential information and trade secrets, an overview of the remedies available to a business in the event there is a breach or a threatened breach. And finally, we'll hear from Jordan, who will provide some employment-focused tips to help with protecting confidential information. Given just how expansive this area, the webinar is only a quick canter through some of the key topics. For that reason, we've not touched upon everything, including database rights and patents, each of which would deserve their own standalone webinars. If therefore you have any questions you'd like to pick up on the back of this webinar or generally, which may be specific to you or your business, please do get in touch with the team and we'd be happy to consider this further with you. So what is confidential information? Well, perhaps a little unhelpfully, confidential information would be defined as information that is protected by the law of confidentiality. Of greater help, therefore, the law of confidentiality is an equitable principle that has been developed by the courts since at least the 1800s and subsequently refined by case law, principally around the concept of protecting against the misuse of commercially sensitive material. Almost any type of information may be regarded as confidential, and whilst not an exhaustive list, frequent examples we in the commercial litigation team encounter include recipes, business methods, financial and cost information, customer lists, supplier lists, business plans, to name but a few. But what distinguishes that information as confidential as opposed to any other information? Well, on that front, in order for information to be protected under the law of confidentiality, the courts have helpfully developed a three-limb test as set out in the case of Coco versus A. Clarke Engineers Limited. The first limb is that the information itself must have the necessary quality of confidence. Whilst a somewhat intangible concept, in reality, this ought to be relatively straightforward to establish in most circumstances. For example, in the case of a secret formula or confidential customer lists, which where rather this information has that intrinsic quality of confidence. The second limb is that the information must have been imparted in circumstances importing an obligation of confidence. That is, objectively, whether the recipient knew or ought to have known the information was confidential. For example, an obligation to keep information confidential may be imposed by contract, for instance, where businesses are exchanging information in either direction pursuant to a non-disclosure agreement, or it might be implied because of the circumstances in which the disclosure is made, or because there is a special relationship between the parties, for instance, that of an employer or employee. And finally, the third limb is that there must be an unauthorized use or threatened use of that information to the detriment of the rights holder, where the recipient will often be aware that the information is confidential and seeks to cover its tracks. This limb is often the most difficult to satisfy in practice and will likely require compelling and contemporaneous evidence of appropriation and misappropriation. One example that typically arises in practice for us is where an employee leaves to work for a competitor and before leaving downloads a client or supplier list or some other document which is regarded by the business as confidential. The employer will be aware that the information is confidential, and the clear inference is that the employer has no reason to take it other than to use it for his or her own purpose or for use by a competitor. As I previously mentioned, the difficulty we encounter with satisfying this limb is in establishing clear evidence that the information has been appropriated. And it is often in those circumstances that the rights holder should consider not only the steps it should be taking immediately to preserve and interrogate its own data and IT systems, But if in fact it needs to go one step further and seek orders from the court requiring the delivery up and preservation of information by the recipient, for instance, by way of a search order, or alternatively what is known as an imaging order. Understanding what each of these limbs means in practice will be highly fact-specific, albeit the three limbs provide a useful framework when approaching a potential claim. The important feature of confidential information that it has commercial value, precisely because it is not known or available to the outside world. The owner of the confidential information or the rights holder therefore enjoys, or at least perceives that it has, a competitive edge in the marketplace over its competitors. Of course, what that information is or what its importance is to the business will be highly specific and on a case-by-case basis. Importantly, confidential information loses its protection once it is disclosed into the public domain. That is, unless it is protected by some other means, such as copyright or patent rights, which for the reasons I explained before are not covered in this talk. Hence the real importance of mitigating the opportunity and the risk of wider dissemination. For that very reason, many businesses deploy restrictions to assist them in protecting their confidential information. The two main examples of where restrictions are commonly found in industry and with which I expect all of you will already be familiar include confidentiality agreements or non-disclosure agreements or NDAs, or restrictive covenants, for example, within the context of employment contracts. These are just some of the tools available to businesses to protect their confidential information. And Robert will pick up later in this webinar what other practical steps may be available to businesses to help with mitigation and guard against the potential loss of that information. Which brings me to the end of my section of this webinar, you'll be pleased to know. And so I'm happily passing across to my colleague, Robert.
Thanks, Sven. Good afternoon, everybody. My name is Robert, and for my section of the webinar, I'm going to provide a short overview of the trade secrets regime and how that works alongside the duty of confidentiality. After that, I'll set out some practical steps that a business can take in order to protect its confidential information and trade secrets. And finally, I'll set out some of the remedies available where there has been a breach or a threatened breach. So firstly, what are trade secrets? As Sven has set out, certain information is confidential and therefore protected by the law of confidentiality. However, there are some forms of confidential information that are also classed as trade secrets. Trade secrets are secret information typically relating to an industry which gives the owner of the secret a competitive advantage, and it's information that has commercial value to the owner, and if it was ever disclosed, then this could be very harmful indeed. Examples of trade secrets include secret industrial processes, databases of customers, formula and recipes, for instance, the Coca-Cola recipe, and algorithms such as Google's search platform. And in addition to being protected by the law of confidentiality, provided that that three-limb test is met, trade secrets also enjoy parallel protection under the Trade Secrets Regulations 2018. These came into force in the UK in June 2018 and implemented the EU Trade Secrets Directive. So the trade secrets regulations define trade secrets as any information which is secret. It has commercial value because it's secret, and it has been subject to reasonable steps to keep it secret. It's perhaps that third element, reasonable steps, which is probably the most significant here, since it requires the owner to demonstrate it's taken positive steps to document and maintain the security and secrecy of the trade secret. So one of the key features of the trade secret regime is that unlawfully obtaining a trade secret is immediately actionable, meaning there's no requirement for the owner to show that the secret's been used or disclosed to a third party. And that represents a major difference between the law of confidentiality and trade secrets. and arguably makes the enforcement of trade secrets much more straightforward. However, it's worth highlighting that the law of confidentiality in the UK does sometimes provide for wider protections than those available under the regulations, and I'll just touch upon that point later when I run through the remedies. So this next section will focus on how confidential information can be protected and if there are any practical steps that can be taken. So as we've discussed, confidential information is protected by the law of confidence, and if it's a trade secret, then the regulations may also apply to provide an extra layer of protection. However, there are a number of practical steps that a business can take to establish, maintain, and protect confidential information and trade secrets. And I'll just run through a few of those now. So the first practical step is restricting access to confidential information. And that's to ensure that the information which is regarded as confidential is shared on a need-to-know basis. And that limits the scope for disclosure of the information, whether that's intentional or accidental. For instance, businesses can restrict access to confidential processes and secret projects. They can do that by requiring that only certain staff members receive security clearance, and also by ensuring that a proper log is maintained of who receives the information and when that information is received. Secondly, labeling documents as confidential. If there are any documents which do contain confidential information, then it's essential these documents are appropriately labeled so there's no ambiguity about their confidentiality or importance to the business. And just a cautionary note here, labeling a document as confidential does not automatically make it confidential. And I just raise this because indiscriminate labeling of documents might have the opposite intended effect and might actually devalue the meaning of the term when ascribed to documents. So I would just advise that it is only those documents which contain confidential information which are marked as confidential. So moving on, we can consider limited disclosure in the context of negotiations. So in certain circumstances, it might be necessary to share information, for example, on a shared project or joint venture in the course of a business sale. In these instances, you might consider holding back your most valuable information, at least until you've reached an advanced stage of the negotiations, or if you've actually got express contractual protections in place to protect the information, such as an NDA. So next, it would be to implement firm-wide policies for know-how and personal data protection. So employee training should extend to giving practical guidance and training on topics such as how to keep information confidential and best practice such as frequent changes to passwords, keeping passwords secure by not sharing them or writing them down, avoiding using USB sticks where possible to store data because these can be easily lost or stolen, using encryptions and password protections when sharing data, and generally being careful when sending emails and ensuring that emails are sent to the right address. And one specific example I'll mention concerns metadata, which is found in electronic documents. So in the case of a document containing confidential information, the metadata might include information about the author, the file size, the date the document was created, and keywords. However, metadata can actually reach further than this and include earlier comments to a document, rolling drafts, and prior amendments, all of which you might not want a recipient to see. So there's specific software available on the market which can be used to strip metadata on documents sent by email. Also, the author can convert the document to a read-only PDF, which strips out the metadata entirely. Provide training to employees about IT issues. IT awareness training can be a very useful reminder to employees to take care when using electronic devices, particularly in public places where there's a shared Wi-Fi network, for instance. and when working from home, which has obviously become far more prevalent in the past 16 months or so. Ensuring that security is appropriate and up to date. There's not a great deal to say here, but given that most confidential information is stored electronically in this day and age, it's important to emphasize the importance of implementing up-to-date cybersecurity measures such as firewalls, secure emails, and encryption to protect the system storing confidential information. And that would be in addition to the physical security measures in place. Keep contemporaneous records, and that touches upon what I mentioned earlier with regards to sharing information on a need-to-know basis. Maintaining a detailed log of what projects each employee or consultant is working on can help identify sources of any breach and forms part of an ongoing risk management strategy. And finally, be vigilant. As with all businesses, I can't stress enough the importance of being vigilant at all times. In particular, be mindful of parties who've received your confidential information and may have access to it. And also be mindful, for instance, of employees who suddenly hand in their notice without any obvious reason and are very keen to leave immediately. Of course, that could be for any number of reasons, but might also be a sign that they're intending to compete and to use confidential information to help them or a competitor gain a head start. So those are some of the practical steps for protecting confidential information. Now, going back to the law of confidentiality and trade secrets, I'm just going to provide an overview of the remedies that are available where there has been a breach or threatened breach, despite all of the protections you might have put in place to protect your information. So what are the remedies if there is a breach? So if confidential information has been unlawfully obtained, the remedies following a successful action include an injunction, damages, and or an account of profits. So just taking each of those remedies in turn, an injunction is potentially the most effective remedy here since its purpose is to prevent the unauthorized use of confidential information. In this context, injunctions have two main purposes. Firstly, to prevent the person using the information for themselves, for example, to gain a head start or a competitive advantage, and that's typically known as a springboard. And secondly, to prevent the person from disclosing the information to others, such as a competitor. And it's important to note that injunctions can be obtained against the person that's taken the confidential information and also against a third-party recipient, where that recipient knew or ought to have known the information was confidential. I'll go on to damages, which are in some respects an addition or an alternative to an injunction. So at their heart, damages are designed to compensate the owner of the information for losses arising from misuse. So the assessment of damages depends on the nature of confidential information, its value, and how it's been misused. The formula for assessing damages depends on the facts of each case and will require a careful analysis of the circumstances. But briefly, damages can be based on the notional value of the information. For example, the price a willing buyer would pay for it. Consideration might also be given to whether the information can be licensed and how much it would cost to license that information to a third party. And if misuse of confidential information causes the owner to suffer a financial loss, say a loss in sales, then damages might be assessed on the profits lost as opposed to the notional value of the confidential information. And an example here might be where an ex-employee joins a competitor and unlawfully uses a list of customers belonging to the ex-employer in order to divert sales to a competitor. In that example, there would be a direct correlation between misuse of confidential information and loss suffered for the purposes of assessing damages. And then finally, an account of profits is an alternative remedy to damages. It's an equitable remedy available at the discretion of the court. The principle behind it is simply to compensate the owner for the unlawful profits made by a third party as a result of the exploitation of the confidential information. This can be a powerful remedy in cases where information's been commercially exploited by a competitor and that competitor has directly profited from any misuse. And finally, I will just mention remedies under the trade secrets regulations. As I mentioned before, the regulations set out separate remedies for breach of trademark, or breach of trade secrets. And these are similar to the common law remedies for breach of confidence. However, the difference here is that the regulations expressly set those out. As shown on the slide there, the regulations provide for interim measures to stop the use or disclosure of a trade secret, injunctions and other protective measures such as product recall, delivery up and destruction of goods, and an assessment of damages. So all of these things are available under the law of confidentiality, and helpfully the regulations state that where the remedies under common law provide wider protection than the regulations, then the trade secrets holder can apply for those common law remedies in addition to those under the regulations. So that's my section complete. For the final section of this webinar, we move on to Jordan, who is going to share his 3 employee-focused tips for protecting confidential information.
Thanks, Rob. Employees during their employment will have access to confidential information, and businesses will want to ensure that that information remains protected post-employment. The first tip is to ensure that the contracts have a confidentiality clause. The clause should prohibit the retention, use, or disclosure of confidential information post-employment. It's also sensible to set out non-exhaustive examples of what the business considers to be confidential information. This way, a business can easily identify the employee's breach in support of any of the claims referred to by Rob previously. Equally, giving examples will act as a good deterrent to any employee planning to take any information that they would not automatically assume is confidential. As Rob has discussed, businesses should make sure that confidential information given to employees is labelled as such, but shouldn't do so unnecessarily. To further protect confidential information, a business could, if it wished, ask a departing employee to affirm any contractual confidentiality provisions. The second tip is to use a garden leave clause. Now, if it's unclear if a business's information is confidential or merely useful in the hands of another, or where it will be difficult to police whether such information is being used, garden leave is a good option. Garden leave is a period of time during a notice period in which the employee is stood down from any duties. They may be excluded from the office and any IT systems and is asked to have no interaction with colleagues or customers. Given that commercially sensitive information is often only sensitive for a period of time, removing an employee's access to the business will mean that any information they had access to before the garden leave is less likely to be useful post-employment. It also means that they will not have access to any new information that is likely to be useful or remain commercially sensitive post-employment. The third tip, excuse me, it's flying past me. We were promised technical glitches, so here it is. The third tip is to use restrictive covenants. Businesses typically use restrictive covenants to either A, protect trade connections, and or B, to protect confidential information. Whilst trade connections are usually protected using non-solicitation and non-dealing clauses, confidential information is protected with the use of a non-compete clause. Now, a non-compete clause typically stops a departing employee from working on their own account or for a competitor within a certain area geographically and a duration of time post-employment. This mitigates the risk of a departing employee taking and using confidential information either for themselves or a competitor, and either giving them or that competitor any competitive advantage over the business. Non-compete clauses are more easily justifiable and enforceable in cases where it is particularly important to protect confidential information. And to make sure that the covenant can be relied upon, businesses should make sure that the duration of any non-compete goes no further than the length of time that the information remains confidential or commercially sensitive. So that does bring us to the end of this webinar. Sven did promise 25 minutes, and I think we're on time, so hopefully we're not taking too much of your day. Obviously, we've flown through the law of confidentiality and trade secrets, and we really do hope that you found it useful. That just leaves us with questions and answers. If you'd like to populate them within the Q&A tab at the bottom, we can then go through them and answer as many as we can. Finally, as a reminder, this webinar is recorded and will be circulated to you later today. If you won't mind, we're just going to take 30 seconds to go through those questions, so please bear with us.
Right, so we've had a few through. Jordan, start with you, given that you've just finished. The questions asked, what if we don't have garden leave provisions in our contracts of employment?
Yeah, it's a great question, and I think as obviously the delegate has sort of noticed, is a garden leave clause does need to be in the contract. It's not an implied term, so we would need to rely upon it in the contract, because as a starting point, an employee has a right to be given work. So to expressly contract out of that, it needs to be in the contract. Of course, if we don't have it in the contract, and hopefully you're in a situation where the employee hasn't departed or has intimated departing, it might be an opportunity to look at varying the current contracts and entering into garden leave provisions. I suppose for those employees, for those companies with employees that have already intimated or are on the way out, they could take a commercial risk. However, I would stress that given an employee is entitled to be given work, they may claim a constructive dismissal. And in the case of a constructive dismissal, they also place any restrictive covenants at risk. So there might obviously, you would need to, I suppose, assess the risks against one another.
Thank you. And Rob, a bit of a curveball here for you, given that we expressly said we weren't going to talk about database rights, but someone's asked the question, perhaps you might explain what they are, whether or not they're separate rights, confidentiality and trade secrets.
Gosh, yeah, that is a bit of a curveball, all right. But yeah, I was expecting the question perhaps to come up. So I
think your desk fan, Rob, is.
Oh yeah, apologies. Yeah, I think it would be helpful if I just gave an overview of database rights. It is, the short answer is yes. It's a separate regime entirely to trade secrets and confidentiality. It protects databases, so perhaps it's useful to set out what databases are. A database is simply a collection of information that's been organized in a methodical or a systematic way that enables the user of the database to access the information, whether electronically or by other means. So I think a good example of a database, and a simple one, might be a library catalog, an online library catalog that allows the user to browse through various books and extrapolate information about those books. So that's clearly a a database of information with references to specific pieces of information that allows the user to find them. So when we think of databases, we could think of just collections of any material, really, from client files to schedules, documents, architect's drawings, music, sounds. Virtually anything can be part of a database so long as it can be organized and stored. In the just thinking in the UK, the database regulations apply, and that's an implementation of EU law. And to my knowledge, they do continue to apply after Brexit, albeit I believe there has been some amendment to the database regulations to ensure that UK databases created after the transition period are still protected. So effectively, the regulations protect copyright in the structure of the database itself, and also the investment that the creator has committed to creating the database itself, whether that's financial or human resources in obtaining and organizing the data. And finally, just the impact of data rights is that it prevents the unauthorized use, extrapolation, or republication of contents in a database without the owner's permission. So as I said, it's quite a complex topic, and I'm happy to answer any specific questions that come in later, but I hope that's given a sort of a helpful overview.
No, thank you, Rob. And yeah, no, that's really helpful. We've got another question. I'll take this one, which is a little easier than the one that you just received. What happens to the forensic image when an imaging order is made? Well, look, as the name suggests, purpose of an imaging order is to simply make an electronic image of data. It's deployed for the purpose of preserving potentially relevant evidence, particularly if there are concerns that unless the order is made, that data will be lost. The usual order made by the court, in answer to the question, is for the image to be preserved in the hands of an officer of the court. The original devices are then returned, and then directions are made regarding disclosure. Importantly, and this is a point which lawyers unfortunately often get wrong, not just their clients, is that if the applicant wants to inspect the image, for instance, he wants to find specific items or stop the onward dissemination of confidential information, then this must be expressly approved by the court. And this is particularly important because applicants sometimes think, albeit wrongly, that the imaging order itself allows inspection, and it doesn't. And the question of imaging and disclosure, in other words, reviewing the image, are entirely separate issues and require very careful handling. And there was a case last year in the Court of Appeal where the applicant's solicitors made an absolute horlicks of the task and risked strikeout. So again, that needs sort of very careful approach. But just sort of reviewing everything, I think we've covered everything off, and I'm mindful that we've run a little over, but it seems to me that represents a natural close to matters. So all that leaves for me to do is thank you to everyone for taking time out their afternoon and joining us and listening to us. And of course, should you have any questions on the back of this or just want to run any ideas, please get in touch with the team, and we'd love hearing from you. So many thanks.